Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS Legal Hotline Lawyer. And today's video is something that you probably have heard me talk about before if you've ever been to a class that I teach, or really if you've been listening to videos for very long. And the answer I'm going to give you is the answer to the question that I give on the legal hotline when somebody asks me a question that says something along the lines of, do I have to disclose, or worse yet, must seller disclose that, and here are some of the doozies we've received lately. Must seller disclose that the seller's house is haunted? That the seller's house is the location where somebody recently committed suicide? That the seller's home is located somewhat near to a homeless camp? That the seller's home includes unpermitted construction? These are just generic examples of some of the disclosure questions that I get asked. I'm asked that question, must seller disclose, fill in the blank, at least once and usually more than once a day. And unfortunately, the only answer I can give to that question is, I don't know. I don't know what seller has to disclose. And moreover, you don't know what seller has to disclose, because anytime you determine what a seller does or doesn't have to disclose, you take the facts of the seller's scenario, you apply them to disclosure law in Washington state, and you reach a conclusion based on the application of facts to the law as to whether or not disclosure is necessary. I hope you realize that that is the practice of law. Unless you have a law license, you are not licensed to engage in that practice of law, and you don't have insurance to support you if you get it wrong. I have the license, but I don't have the client relationship. I don't represent your sellers. I can't tell your sellers what they do or don't have to disclose. So brokers, I know it's frustrating because the seller's looking at you saying, well, what are you here for if you can't tell me what potable water is, or if I have potable water, why are you here? But brokers, the answer is, seller, I am so sorry, I can't answer that question for you. You've hired me to provide real estate brokerage services to you, to help you market your home and find a buyer, and I am going to do that job better than anybody on the planet, anybody else on the planet could do for you. But seller, you haven't hired me to practice law on your behalf because I don't have the license or the insurance to do that. And what you've asked me is a legal question, and I simply cannot answer the question for you. You've got to talk to your own. If you can't figure out the answer to that question, seller, you have to ask this question of your lawyer. I can't answer the question for you. It'd be one thing if that was the end of the video, but it's not. It's really only the beginning of the video, because even though that's your answer to the seller, that does not solve your problem of having to figure out whether or not the issue that's a concern to the seller has to be disclosed. Because even though you can't tell seller what seller has to do, you still have to know whether that issue has to be disclosed, because you, broker, have an independent duty, independent of your seller, to make disclosure yourself. That duty arises for you under two different Washington statutes. The first being the agency law, where you have a duty to disclose material facts. You have a duty to disclose material facts. Material fact is defined as substantially adverse information impacting the condition of seller's property. And you have a duty to disclose material facts, existing material facts, that are not ascertainable or readily observable. So seller, you're still going to, brokers, you're still going to have to do that application of the seller's fact pattern to your disclosure obligation and reach a conclusion about whether or not you have to disclose. But when you're analyzing this for your own disclosure obligation, you're not practicing law, you're complying with the agency law. You may need help with this analysis from time to time. Talk to your managing broker. In really tough situations, your managing broker, you and your managing broker may talk to your firm's lawyer. I'm still not your firm's lawyer, so I'm still not going to be the one who helps you with that analysis, but sometimes you do need a lawyer to help you conduct that analysis. So get the help that you need on a case-by-case basis. The second statutory provision that obligates you to disclose conditions within seller's property is an obligation that arises, believe it or not, under the Seller Disclosure Act. The Seller Disclosure Act says that a broker is not liable for sellers' errors, omissions, or inaccuracies in the Form 17 if broker had no actual knowledge of those errors, omissions, or inaccuracies. So the reverse implication of that is that if you do have actual knowledge, then you are liable, which means, brokers, you must review seller's Form 17 or their disclosure statement and correct any errors of which you know. So if the seller had told you when they listed the property that the roof leaked 3 years ago, but they fixed it, it doesn't leak anymore, but on the question that asks, has the roof leaked in the last 5 years, they say no, you know that's wrong. The answer is yes. Brokers, go to the seller in that instance and say, seller, this form is really confusing. I know how easy it is to misread the question and the check mark boxes, but really use a ruler. And if you use a ruler, you can see that this question that asks about has the roof leaked in the last 5 years, you answered no, and I'm certain that the answer is yes because you told me the roof leaked within the last 3 years. 99 times out of 100, that seller's going to say, oh my goodness, you're right, I'm sorry, that was wrong, and they're going to fix their answer. Most of you are never going to deal with a seller who doesn't agree to fix their answer. But in the off chance, the very rare circumstance, you're working with a seller who intentionally misrepresents the condition of their house or intentionally answers incorrectly a question on the Form 17, it is your obligation under Washington law to correct that error. You would never, ever, ever change the seller's answer on the Form 17. Instead, you would communicate to the buyer broker in a provable way what your actual knowledge of that issue is. You should let your seller know that you're doing that. You do not need your seller's permission to do that because you are obligated by Washington law, both under the Seller's Disclosure Act and under the agency law, to disclose material facts or to correct known errors and omissions in seller's completion of the Form 17. If you have questions on this topic or any other, visit the Washington Realtors website at warealtor.org and ask me a question through the Legal Hotline. Thank you for being a Washington Realtors member.